After the attacks by Israel and the United States, Iran moved to assert control over the Strait, followed by a blockade by the United States of Iranian ports. And needless to say, the restrictions on the passage of vessels brought on by the war have brought shipping to a standstill, a stark reminder of how much we depend on the free flow of passage through these important critical waterways. The Strait of Hormuz covers many different areas of international law, but this webinar will be focusing specifically on the interactions between the law of the sea and the law of naval warfare. And I'm so delighted to have our three speakers here today, although they need no introduction. Dr. Niloufar Orel, the Director of the Center for International Law at the National University of Singapore and member of the International Law Commission. She's a world-renowned expert on law of the sea and has researched and written extensively on international law governing straits. She gave the Hague Academy of International Law special course on straits last year, and she is also the co-editor of the International Straits of the World book series published by Brill, along with Dr. Alexander Lott, which will be released soon. Professor Robert Beckman is an emeritus professor at the Faculty of Law at NUS, the founding director of CIL, and until last week was the co-head of the Oceans Law and Policy team. He has decades of experience in teaching, researching, and writing on law of the sea, and is known as one of the world's authorities on the application of law of the sea in Southeast Asia. Last but certainly not least, we have Dr. Alexander Lott, who is a research professor at the Norwegian Center for Law of the Sea at the University of Tromsø, the Arctic University of Norway. He is also another world-renowned expert on law of the sea and law of naval warfare. And as I mentioned earlier, is Niloufar's co-editor of the International Straits of the World, published by Brill. He has written a lot on law of naval warfare and straits. The way this is going to go is I'm going to be posing a series of general questions to our panelists, and hopefully we will have a very interactive discussion, and we will reserve about 20 to 30 minutes for Q&A from the participants. So please feel free to put your questions in the Q&A box, and we will hopefully get to some of them. So without further ado, I would like to pose the first question to Professor Robert Beckman. Could you give the audience an understanding of the legal regime governing passage, particularly transit passage, through straits used for international navigation under UNCLOS?
Okay, thank you, Tara. The regime of transit passage is linked to the agreement during the law of the sea negotiation.
Oh, sorry, Prof. Yeah, yeah. Okay, now I can hear you. You were silent for a while.
Can you hear me now?
Yes.
Okay. Sorry, the regime of transit passage is linked to the agreement during the law of the sea negotiations to allow coastal states to claim a 12 nautical mile territorial sea. The major powers insisted that innocent passage regime would not meet their interests, particularly in moving their navies around the world with air cover above and submarine cover below. Therefore, a new regime was created called Straits Used for International Navigation, which applies to ships passing from one area of high seas or economic zone through a choke point to another area of high seas or economic zone. For example, when passing from the Indian Ocean to the South China Sea, a ship would go through the territorial waters of Indonesia, Malaysia, and the Straits of Malacca, and in area they would go through the Singapore and Indonesian waters in the Strait of Singapore. The transit passage means it's the freedom of navigation and overflight for purposes of continuous and expeditious passage through a strait. The extent that the coastal states can regulate it is they may designate sea lanes and traffic separation schemes with approval of the International Maritime Organization. They can create mandatory ship reporting schemes. They can adopt laws and regulations, but those laws cannot have any practical effect of denying, hampering, or impairing the right of passage. And they must give publicity to any danger to navigation, and very importantly, there can be no suspension of the right of transit passage. Now, the ships that are exercising the right, they must give proceed without delay. They must refrain from threat or use of force against the coastal states and refrain from activities other than those incident to their normal passage. They must comply with the generally accepted international rules, procedures, and practices established by the IMO on safety of navigation and ship source pollution, and they may not engage in any research or survey activities. Now, the major difference between transit passage and innocent passage is that it includes overflight of aircraft, and submarines can navigate in their normal mode, which means underwater, whereas in innocent passage, they must surface and fly their flag. The other difference is that transit passage cannot be suspended by the coastal states. I think I'll leave it for there if you have any other questions.
No, that's great. Thank you, Prof. You really summarized it very quickly. Can I now turn to Nilofer and to ask her, how does the UNCLOS transit passage regime in straits apply to the Strait of Hormuz?
Yeah, thank you so much, and really happy to be with these wonderful panelists. And I see we do have a lot of interest in this. And many thanks to Bob for an excellent summary of what is actually a rather complex
Yeah.
and technical area of the law. So you did it really well. So the Hormuz Strait, well, as Tara already mentioned, and I think it's important to remember that we're so focused on Iran, actually Oman is also bordering the strait. Um, and back in 1973, both Oman and Iran at that time established a traffic separation scheme, which is still operational. And I think that's important to recall. And it's important. And that was actually before the Law of the Sea Convention, of course. Now, what makes the Hormuz Strait a bit more complex? And while it would fall under a strait subject to the transit passage regime under the Law of the Sea Convention, the problem is, while Oman is a party to the convention, signed and ratified it, Iran only signed it and has not ratified the Law of the Sea Convention. It's the same for the 1958 Geneva Convention, by the way, but we'll focus on the Law of the Sea Convention. So what that means is that the provisions of the Law of the Sea Convention do not apply, are not binding upon Iran unless they would constitute customary international law. But here's another, I call it wrinkle, is that Iran, when it signed, it included a declaration, a statement, and said, in our view, I'm basically paraphrasing it, that the transit passage regime is part of a package deal that Bob has just explained very clearly, and therefore it only applies to parties to the Law of the Sea Convention. And this has been voiced by Iran over the years, in particular against the United States, who's not a party to the Law of the Sea Convention. And the question then arises, well, would Iran then constitute a persistent objector? And a persistent objector would not be bound by transit passage if it is customary international law. And I don't want to go into details because if you look at the work of the International Law Commission, Identification of Customary International Law, if at the formation of the rule of customary international law, a state objects and continues, then it would not be bound by. So what would it be bound by? Well, it would certainly be bound by non-suspendable innocent passage, which, since the Corfu Channel case in 1949 was recognized as customary international law. So it goes down to what Bob says, what's important, whether it's non-suspendable innocent passage or transit passage, all merchant vessels, all vessels, have the right of passage. We'll just say that, unimpeded passage. And the only difference, as Bob said, is if you're a submarine or an airplane, then it's a different story between transit passage or the procedure for getting a traffic separation scheme. So I'll just stop here, but that is the situation for transit passage or passage in the Hormuz Strait in times of peace.
Thank you. And then if I was wondering whether you could also talk a little bit about the prohibition on tolls
Ah,
through
yes.
passage in territorial waters.
Yes. So that's also very clear. I know suddenly everyone's talking about tolls and
Yes.
passages. I think the fathers of UNCLOS must be,
Rolling in their graves, right?
those who are alive and those who are not alive and those who are alive. Article 26, when it comes to innocent passage, is very clear, which says that no charge may be imposed for passage just for passage. The only time a coastal state can charge is for services. For example, let's say pilotage, or you want a tugboat, maybe, and that. And that would apply to transit passage as well. I think that is absolutely clear. Customary international law. I think there's no doubt whatsoever that tolls cannot be imposed unless there's an agreement. And the only one that I know of is, of course, the Turkish Straits, the 1936 Montreux Convention. It's not called a toll, but there are certain fees that are assessed for certain services rendered. Now, and we may talk about this a little bit more later on, Law of the Sea Convention does have Article 43, and the Malacca Straits is the only one who has actually created this voluntary fund to address these issues of the cost. I call it the cost of being a strait. It's expensive, you know, and so understandable. But the system has already provided a way for states to cooperate voluntarily to address these issues. But we can maybe, and Bob is here, the real expert on that.
And Nilofer, I was wondering also just briefly, because a lot of my friends who are not international lawyers or lawyers always ask, well, what about, the Panama Canal, the Suez Canal, right? They have an administrative system charging tolls. Could
Mm.
you perhaps explain what is the difference?
Yeah, those are human-made canal
Mhm.
waterways, so they are not under the regime of natural waterways. So they have treaties regulating them, the Panama and Suez. So they're in a completely different category, and not covered by the Law of the Sea Convention. So it's a different category.
Okay, thank you. And I think so. What is clear now from the discussion is whatever it is, at minimum, there is a non-suspendable right of passage, of innocent passage through the Straits of
On the
Hormuz.
Iranian side.
Sorry, yes, on the Iranian side, yes, not on the Oman side. And tolls cannot be charged for passage, except if you are charging for specific services. If I can now turn to Alexander to talk about, how the law of naval warfare, which is part of the law of armed conflict or international humanitarian law, changes or affects this position. Particularly about what is the relationship between UNCLOS and the law of naval warfare, and how does this affect transit passage? And maybe we can talk a little bit about neutral vessels after that, but please go ahead.
Thank you. It's really a great pleasure to join this discussion. So, of course, the Law of the Sea Convention does not regulate matters of war. The law of naval warfare serves as the lex specialis. But this does not really mean that the law of the sea loses its significance in an armed conflict. The legal framework and the rules stipulated in the Law of the Sea Convention in respect of various maritime zones, as well as activities therein, largely continue to apply in times of armed conflict, both in respect of neutral states as well as, to a lesser degree, the belligerent states. Now, the zonal as well as the functional approaches of the law of the sea maintain their significance in an armed conflict. And this means that, on the one hand, the neutral waters, comprising of the internal waters, the territorial sea, and where applicable, the archipelagic waters, maintain their status as neutral waters. But on the other hand, belligerent territorial waters and international waters such as the exclusive economic zone, the high seas, as well as the contiguous zone, are areas different from the neutral waters that I discussed earlier, where the belligerents can engage in open. This is this particular distinction in the context of the Hormuz, because the question arises as to whether the Strait of Hormuz includes only waters. That is,
Sorry, you're breaking up a
sorry,
little bit, Alexander. Just a little bit. Yeah, if you could just maybe speak a bit louder, there's a bit of gaps in the sound.
yes.
Yeah.
So the question arises as to Hormuz includes only the territorial waters of not only Iran but also Oman, or whether the Strait of Hormuz is split between the belligerent territorial waters of Iran on the one hand and the neutral territorial sea of Oman.
Mm.
If, for example, the Strait of Hormuz comprises entirely belligerent territorial waters, then of course would be in principle entitled to also conduct its hostilities throughout the Strait of Hormuz, including, let's say, laying naval mines in areas falling outside of its. Functionally, to a great extent, the rights and freedoms stipulated under the Law of the Sea Convention maintain their relevance also in naval warfare. So, in the case of the US and Iran warfare, we are, of course, in this context, mostly concerned with the extent of passage rights that apply in and over the Strait of Hormuz. And this particular functional approach is really in everyone's minds when we discuss the legality of the Iran's closure of the Strait of Hormuz, or indeed the United States blockade of the Iranian ports and coastline. You wanted to discuss, Tara, also the impact of the naval warfare on the transit passage regime, right?
Yes.
So I'll try to be quick.
You have time.
Of course, straits gain and increase significance in an international armed conflict. Now, according to the Corfu Channel case, as already mentioned by Nilofer, states are required to ensure the safe passage through an international strait to neutral ships in times of war. Therefore, we need to distinguish between two groups of states, belligerent and neutral states, when it comes to this particular functional approach in terms of passage rights in an armed conflict. In respect of Iran's enemies, the right of transit passage no longer applies in the Strait of Hormuz. It is possible to close an international strait temporarily to the enemy's ships and aircraft. In respect of neutral states, however, the right of transit passage, as also outlined by Nilofer, continues to apply in and over. So it also includes the freedom of overflight for all functional purposes under the concept of the right of transit passage over the Strait of Hormuz. Neutral ships and aircraft cannot be attacked while transiting the Strait of Hormuz, in legal terms, of course. This implies that, in principle, a strait state nor any other state party to the Law of the Sea Convention is able to temporarily close, for example, by means of laying mines, an international strait for the navigation of neutral ships in an international armed conflict. Now, Iran is entitled to lay minefields in the Strait of Hormuz, but at the same time, it is required to ensure the expeditious and safe passage of neutral ships through the Strait of Hormuz. We have noticed throughout the past weeks that Iran has established a safe corridor through its internal waters.
Mhm.
But demanding ships to pay a toll for use safe corridor is completely, manifestly against the law of the sea convention regime, as also outlined by Nilofer. Now, I think in the context of the law of the blockade, the question of the neutrality of Oman has really particular significance. Oman declared that it remains neutral in reaction to reported Iranian drone strikes against its territory. If Oman were to be considered as a belligerent in the international armed conflict due to the Iranian attacks, then, as mentioned, Iran could lay naval mines also in the territorial sea, wherein actually you have the main shipping lanes, the traffic separation scheme in the Strait of Hormuz proper. The Omani territorial sea would then no longer comprise neutral waters. Instead, as discussed, both Iran as well as Oman would be considered as belligerents. But this is really unclear to me. What is the status of Oman in this particular international armed conflict? And what is the status of the Omani territorial sea? Thanks.
Thanks, Alexander. And I mean, just on a related question, which I see from our Q&A, very briefly, because it relates to the point you're making, should Oman and the other GCC countries be considered belligerents since they have been attacked by Iran?
Well, I think it is indeed a very significant question if we discuss, let's say, the questions of blockade, then the status of the other Persian Gulf coastal states as either neutral states or belligerents is really at the very heart of this whole, so to say, legal framework. Well, if all the other, or at least the majority of the coastal states of the Persian Gulf would be considered as belligerents, then one could argue that, let's say, Iran's closure of the Strait of Hormuz is perhaps, in legal terms, a blockade of its enemies' ports and coastlines in the Persian Gulf. However, of course, the other Persian Gulf coastal states have insisted on their neutral status in the ongoing international armed conflict. And I think it largely boils down to, the state practice of not only the Persian Gulf coastal states themselves, but also other states, how they perceive, let's say, Saudi Arabia, the Emirates, Qatar, Bahrain, Iraq, as as to this particular armed conflict. But we have seen that despite even the Iraqi territory being attacked by Iran, Iran, on the other hand, explicitly allowed Iraqi ships to exit the Persian Gulf via the Strait of Hormuz afterwards. So this really goes against the whole logic of imposing a naval blockade, and which is also the reason why I'm very reluctant to consider that Iran has imposed a naval blockade against all the other Persian Gulf coastal states. So I would rather tilt towards saying that the other Persian Gulf coastal states have maintained their neutral status and they should be considered as such. But of course, international humanitarian law, on the other hand, also is concerned with the objective reality on the grounds, but there are hostilities taking place between the states, and you have perhaps a bit conflicting situation from the perspective of, on the one hand, international humanitarian law, and on the other hand, the state practice as such.
Okay, thank you very much for that in-depth explanation. There are a lot of questions on the chat about the US blockade, and perhaps I can now turn to Nilofer to briefly describe what is the legal basis of
Yeah.
the US blockade and how does it work?
That's a tricky. Well, first of all, and I have to say, I think Alexander has really laid out the complexities, and the problem is that we're dealing with law that is based on somewhat antiquated, the law of naval blockade, the naval warfare. It's a lot of it based on what we call customary international law. There is the 1994 San Remo Manual, prepared by experts, not states, and is considered to be reflective of customary international law. Then you have individual naval manuals, and then you have alternative new ones coming up, the Newport Manual, and they're updating the San Remo Manual. But I think what you really see is that how fit for purpose is the existing customary international law. And I say that because the point about the Gulf states, and they're in such a very terrible situation. And the problem is because they have US bases. And so if having a US base ipso facto then makes them a target, which, if you look at the San Remo manual, it would seem that way, but that doesn't seem right if they're declaring their neutrality. And obviously they have the right to self-defense. And then this issue of blockade. So we have to remember, and I think to me it's very important, and it's not to say one that Iran is correct in blocking the passage of neutral merchant vessels. It should be allowing them to pass, really. But it's using that opportunity. We know why. But it was the United States and Israel that launched the attack against Iran. And the whole basis of the reason they gave has not been accepted really overall. And so if you categorize that as an unlawful act of aggression, even though the laws of naval warfare allow for blockade to block other ports of the enemy, or to block, I mean, it's not just the ports. Israel, because I know from the Mavi Marmara, extended all the way to the high seas and intersected vessels who were openly going to breach the blockade. But yes, technically, the U.S. can, but in my view, I think that the acts of U.S., if they're considered violation of East Kogan's norms, then would not be allowable to do a blockade, but that's something to debate. But there's certain requirements, has to be non-discriminatory, they have to give notice, can't be there to starve out the civilian population. You still have to meet the rules of armed conflict, proportionality. So all these rules still apply, has to be effective. But the end of the day, it's like if the whole purpose was to open the Hormuz Strait to shipping, because we see the impact it's having. I mean, Lufthansa has now canceled 20,000 flights. I mean, Sri Lanka, they're not being able to light their street lights at night. I mean, it's having a real impact. And the United States is imposing a blockade that is blocking passage of merchant vessels. It doesn't make sense. So anyway, I'll just stop there, and perhaps I'm not really an IHL expert at all, but perhaps Alexandra can also add to that, or Bob may have some comments as well.
Yeah. I wonder, Alexandra, if you had any comments to what Nilofer said or any additions, and then we can go to Bob.
Yes, well, as Nilofer also mentioned, we need to separate the jus ad bellum aspects of the ongoing situation from the use in bellow questions. So in my view, I really would approach the US blockade of the Iranian ports and coastline in isolation from the question of the attack against Iran as such. Now, from this perspective, purely technically speaking, the US blockade does seem to tick all the boxes necessary to qualify as a proper naval blockade, distinct from the activities of Iran in and near the Strait of Hormuz. So the US has even clearly met the, so to say, formal requirements, such as the declaration and notification of the blockade. The effectiveness of the blockade is something that, of course, comes down to the particular facts which we might not possess thoroughly at this particular point of time. This is something that particularly the maritime intelligence companies are trying to find out which ships have been able to breach the US blockade and which not. I don't have this sort of information, whether there have been ships that have been able to breach the US blockade. But in principle, what the blockade is really all about is the prevention of all access of ships and aircraft to the enemy ports and coastline, as well as from the enemy ports and coastline to other parts of the sea. So, for example, if the US boards and seizes some ships heading to the Iranian ports outside of the immediate area of the blockaded Iranian ports and coastline, somewhere in the remote areas of the Indian Ocean, it would be lawful if they have declared their intention to ship to sail to the Iranian ports. The question about the attacks against neutral merchant vessels, I think, is really at the heart of all our worries from the global economic perspective. And since you asked this question as well, Tara, would briefly stop on this if possible. I think, well, clearly one cannot attack neutral warships, but the situation really becomes less clear in terms of attacks against neutral merchant vessels. On the one hand, amongst others, some eminent British scholars have supported the position that, let's say, searching for, diverting, seizing, or even indeed attacking or destroying neutral merchant vessels are no longer really feasible courses of action in the modern world. But on the other hand, I would say that various law of naval warfare manuals, including the San Remo manual that was pointed to by Nilofer earlier, and that reflects customary international law in this matter, provide that neutral merchant vessels can potentially be attacked if their actions or characteristics really amount them to having an enemy character. So, in my view, in modern naval warfare, belligerents appear to consider it their right to launch attacks against merchant vessels, including those flying a neutral flag. And this, from the global economic perspective, is, of course, a very worrying tendency. Both Iran Russia in 2022, as well as Ukraine, have all systematically resorted to such a method of economic naval warfare throughout the 5 years' time. And of course, the US is also of the position that merchant vessels, including those that at first sight are neutral vessels, can be attacked based on different legal bases, including that of war-sustaining objects. However, of course, most states do not subscribe to this view. But perhaps what we are seeing in the context of the Ukrainian attacks against Russian shadow fleet vessels, then the US position might be supported not only perhaps by India, but now increasingly so by Ukraine as well. Thanks.
Thank you very much, Alexander. And I think your remarks and everyone's remarks, there's so many questions on the chat, but perhaps we can put a pin on this, on the law of naval conflict, warfare, sorry, and move on to sort of a few remarks from Prof. Beckman, right, on the sort of long-term implications, of the UNCLOS legal order governing straits and other passage regimes, right? And I think, we are based in Singapore, but particularly for Southeast Asia, right, this is a particularly critical question. And I wondered if you have any thoughts on that.
Well, I think my own view is the US-led rules-based legal order that followed the World War II is now seriously under attack and being undermined by the United States, by the Trump administration. What that means for us and the rest of the world, I think the Law of the Sea Convention is still going to be the universally accepted document which people follow. I think in straits such as the Straits of Malacca and Singapore, I think everyone has an interest in ensuring that the Law of the Sea Convention continues to be the legal framework. All three states are parties to the convention. The three states bordering the straits have cooperated and treated the straits as a single unit since the 1970s. They've proposed various mechanisms to improve safety and prevent pollution together to the United Nations, to the IMO. And therefore, I think it's going to have a minimal effect. The difficulty I see is when the US Navy is blowing up fishing boats in the Caribbean and they're interdicting vessels that have links to Iran in the Indian Ocean. I think that lots of questions are raised as to the legal order. And again, the question is, if you interdict a ship that has links to Iran in the Indian Ocean, what are you going to do with it? You're going to escort it back to Baltimore? And difficult, you can't sink it, right? It's a merchant ship that might be linked. And some of the ships are flagged in China or on their way to China. Are you going to interfere with ships in the Indian Ocean that are carrying goods to or from between China and Iran? If so, again, what do you do with those ships? I think the fact that the Secretary of the Navy was replaced in the last 24 hours is another sign to me that there may be some discontent within the US administration as to how this war is being conducted. So again, the major threat, I think, to the rules-based legal order is coming from the United States more than it is coming from Iran, is my view on this issue.
Thanks, Prof. And I think, there's been a lot of, commentary and comparisons made, particularly to the Strait of Hormuz and the Strait of Malacca in Singapore. Now, do you think such comparisons are valid? And perhaps you could also talk a little bit about, Nilofer mentioned the Article 43 cooperative mechanism on the Straits of Malacca and Singapore on environmental pollution and safety of navigation. And what are the long-term or, the long-term implications of this war?
Okay, I think that's a very good question. I think Article 43 may be an answer or may provide a mechanism whereby the states with an interest in passage of merchant ships through the Strait of Hormuz could be working together. That would include all of the Middle Eastern states bordering the Persian Gulf, as well as Oman and Iran, but also dealing with the user states that depend on the oil and other things going through the strait on commercial ships. The way it has worked for the Straits of Malacca and Singapore, they've established what is called a cooperative mechanism. And there's annual meetings at which the major users cooperate with the three bordering states to talk about how do you improve safety and how do you prevent ship source pollution. And the user states have contributed expertise and funding to improve safety and navigation. Now, it's not linked to security, it's linked to safety, but they're very close. And I think this could be an answer because the key, and I think should mention also, is the amount of seafarers that are stranded on vessels in the Persian Gulf because of the blockade and because of the closure of the straits is also a serious problem. So I think it's an area where the shipping industry should clearly be consulted together with the major users and try to work out a mechanism with Iran once the war stops in order to ensure the safety of merchant shipping through the strait. I think it's a model they could be looking at as a potential example.
Yeah. For sure. I mean, it doesn't, it's of course customary international. The Article 43 is arguably not customary international law, but I think it is a very good precedent and practice, for all states bordering straits used for international navigation.
I should also add, let me add one more point. This was the Article 43, the impetus for it actually was back when we were more worried about security in the straits because of the large number of piracy and armed robbery against ships. It was following 9/11. There was concern, but actually it moved from security because Article 43 doesn't mention security. It mentions safety and ship source pollution. But in effect, when you improve safety, you're also improving security. So I think that could be a similar approach in the Hormuz Strait.
Okay, thank you, Prof. Beckman. And Nilüfer, did you want to have say something?
I just wanted to add in, just to remember that it's not the first time. Back in the 80s, there was another war between, Iraq this time it had attacked Iran, and Hormuz Strait was again the scene of what they called the tanker wars. And that went on for like 7 or 8 years. The US also was involved. Many states were involved then. And commercial shipping was attacked. But to my knowledge, we didn't have the same impact we're feeling now. And the US did not impose a blockade. In fact, the US continued to recognize transit passage. And I think the status was not closed per se. I think we have to understand that better, but it's important to recall that it's not the first time, but I have the feeling this is the most serious consequence that globally we are experiencing. So I just wanted to bring that up.
Thank you. We have a lot of questions. I'm going to try and pose a few of them to you. Perhaps coming back to neutrality, the one question from Himanal is, isn't the reality that, okay, enlightening discussion on neutrality, I must say that. However, isn't the reality that most states are in a state closer to non-belligerency as opposed to neutrality? In the immediate region, I'm only aware of Sri Lanka having formally invoked neutrality. Given that the status of neutrality is not automatic but optional, how does this change the legal picture? And perhaps, Alexander, I hate to put you on the spot, but if you have any comments on that.
Yes, sure. I thank you for the question. It's a very relevant question, not only in the context of the Iran war, but also in the context of the Russian invasion of Ukraine. So, for example, do the European and other states supporting Ukraine maintain their neutral status, or is that one of simply non-belligerency? And I think just like these both conflicts have shown to us that indeed there is this worrying trend of attacking neutral merchant vessels by basically all belligerents in these two armed conflicts. We similarly see this rising trend of the use of non-belligerent status. And I think, I mean, from the perspective of the law of blockade, I'm just really thinking out loud here, but I think it doesn't change the picture that much, really, because the law of blockade is really concerned with the question of whether the blockaded area is that of the enemy one. So, are you blockading an enemy port? Are you blockading an enemy coastline? If the Iran is simply kind of blockading the whole world economy, then this does not really amount to the blockade of an enemy port or coastline. The aim of the closure of the Strait by Iran is very different from that of, let's say, the United States when it decided to impose its blockade targeting specifically the Iranian ports and coastline. That would be my very simple and brief answer to it.
Yeah. And there's one question that keeps on coming up is about the effectiveness of the blockade, right? How is, well, the question here is, what is the reason for the qualification in the law of naval warfare that a blockade must be effective? And what is, how do you assess that it is effective? And what happens if it's determined to be ineffective?
Yes, I'll start with the easiest part. So as soon as the blockade is ineffective, then there's no longer a blockade. That's the, so to say, basic rule of customary international law relating to naval blockades. Hence, the reason why the United States must take all means to ensure the effectiveness of the blockade, which basically means that you need to prevent all vessels, but in my view, also potentially at least aircraft reaching the enemy ports and coastline, the blockaded area. As soon as you have exceptions to this, then you have a problem. Then you have questions about whether your actions still amount to blockade. And as discussed, if there are breaches of the blockade by an enemy, by, let's say, even a neutral ship heading to the enemy port, or by a neutral aircraft heading to the enemy port, then the blockade might no longer be in place, and then you would not be entitled to the rights that accompany the blockading power. I am not aware of that sort of pattern in and around the Strait of Hormuz that would point to the ineffectiveness of the US blockade. What I'm more interested of at the moment is what is the effect of yesterday's developments in the Strait of Hormuz in the case of the Iranian boarding and seizure of two neutral merchant vessels on this particular ongoing armed conflict. Does this point to the fact that Iran might still hold some sort of an effective blockade? Does it have the, so to say, operational control over the Strait of Hormuz, over all international navigation heading to, coming from the Persian Gulf? If yes, then this might meet the criterion of effectiveness under the law of naval blockade. But that being said, still the question arises as to, well, who is Iran really blockading, right? You cannot blockade simply the world economy as such. You cannot take the world economy, you cannot hold it as your hostage in terms of naval blockade, in my view at least. You need to have some sort of an enemy port or coastline.
Mhm. Well, thank you very much for that, Alexander. And I think another question that also keeps coming up, and I'll bring it to Nilofer, is this idea. I think Alexander briefly explained it earlier, but this idea of the relationship between the law of armed conflict and the law of the sea. There are questions about, for example, does the right of innocent passage and the right to transit passage override the customary international law on naval warfare? Another question is, would international humanitarian law have precedence over the laws of peace? And in relation to that is, how does it use ad bellum? Why is it not relevant to the fact that the Strait only became closed after the act of aggression by US and Israel? But perhaps, Nilofer, you can just focus mainly on the relationship between the law of armed conflict and the law of the sea.
Yeah, I can. I know Bob raised that as well. And I think, Alexandra's given some really excellent explanations. Um, One thing I have to say is that the information that we receive, I'm not sure what is going on in the Strait of Hormuz. So in terms of assessing, and I'm not answering the question right now, it's actually a question. So, Alexander, I mean, how is the U.S. enforcing this blockade? Because the blockade has to be, again, it's a measure, a weapon to use against Iran. But this is the question: is it though? Is it becoming unreasonable, disproportionate, if it's impacting really the global economy and not just Iran's economy? But it's hard for me to gauge because I don't know exactly, and you may have better information. But going to that, the question that you asked, Tara, um, so there isn't, and this is something that always comes up, the Law of the Sea Convention doesn't expressly limit itself to a certain period, but it is also, as we know, subject to other rules, and IHL is considered lex specialis. But we also know that under the laws of naval warfare expressly recognizes that the right of innocent passage or non-suspendable innocent passage in the case of straits used for international navigation and transit passage for neutral vessels continues to apply. So those rights continue. And we also know in general that, the state of an armed conflict does not, and there's does not suspend states' international obligations under treaties. Those treaties continue. So I think it's just a question of when it comes to the law of the sea. Now, with this naval blockade, for example, it does impact the passage of merchant vessels because that gives very broad powers, really, to the blockading country or state. So, but again, these are areas I really feel that we have more questions than answers sometimes. Warfare has changed. And I know that, states are, experts at least are looking into revisions, but there definitely is a need. And I just know that, in my view, that the current law of naval blockade has areas that certainly could be re-examined. But don't ask me what they are.
But yeah, I mean, it's also an interesting question on what is the law? I mean, where is the law of naval warfare reflected? How is it made? I mean, my former colleague Dita has raised this issue quite often, right? Because we have the the battle of the books, as they say. Well, not really a battle, but we have the San Remo manual, right, which I understand is being revised, and we also have the most recent Newport manual, which is produced by a group of experts from the United States, which may take a different perspective on what, for example, the San Remo manual or other manuals have said. So that is also a very interesting question on who makes the
Yeah.
law of
Yeah.
warfare.
And I just want to say, there's a question, can the doctrine of transit passage be suspended
Yes.
under UNCLOS in situation involving national security threats or armed conflict? Of course, the inherent right of self-defense in the UN Charter, Article 51, always remains. So transit passage certainly doesn't prevent a state from exercising its inherent right of self-defense. Of course, what does that mean exactly? What are the measures? But it has to be, there's always the principle of non-discrimination. It has to apply to all states equally. So I just wanted to bring that up. And that applies also to innocent passage. It's clear, it's in the Law of the Sea Convention as well, that in passage, whether it's transit or innocent, it has to be, non-threatening, peaceful passage. So.
Yes, and thank you for that. Prof. Beckman, I think there's a question, I think directed, well, perfectly made for you. Do falsely flagged stateless vessels have the right of undisturbed passage, innocent or otherwise, in international straits? And this is, I guess, not strictly relevant to the topic of hand, but how can the Strait of Malacca and Singapore coastal states implement the actions called for in the IMO Resolution 1192/33? But I think it also raises a broader question of, and perhaps to all our panelists, this idea of neutral vessels. There's reports of vessels being arrested because they are subject to US sanctions, right? And how do we really determine this distinction, right, between neutral, belligerent vessels? What about vessels which are operated by a company from a belligerent state, but it's flagged in a neutral state? Those are very complex questions. But perhaps the first question we can go to is this issue of falsely flagged states.
Okay, whether it's innocent passage right or transit passage right or freedom of navigation, my view is that ships of all states have the freedom of navigation. Ships of all states have right of innocent passage. It's a falsely flagged vessel. It arguably doesn't have those rights. And therefore, there have been cases where the falsely flagged vessels have been intercepted by the French, by others. The Germans have denied passage rights through their territorial sea with falsely flagged vessels. So this, I think, is something that should be examined more carefully. If the vessels are falsely flagged, they arguably don't have any rights. The whole law of the sea assumes that the vessel has a flag and it is legitimately flagged in that state. If it's not, arguably it doesn't have a right at all. I can't buy a vessel and then without registering it anywhere, fly it on the high or navigate on the high seas. So I think that's a distinction with respect to the shadow fleet that really is outside the ramifications of except there are some shadow fleet vessels that are now being intercepted, or that are shadow fleet vessels that are now are attempting to transit the Hormuz Strait.
Yeah. And I think the broader question is, are falsely flagged vessels always stateless vessels under the law of the Sea Convention?
If they're falsely flagged, again, I think you have to be legally registered in the state whose flag you're flying. Otherwise, you're falsely flagged. You can't be legally registered in Panama but fly a Marshall Islands flag, because then the state that is concerned about this vessel could check with the Marshall Islands, and they say, well, no, they're not registered in our territory. Then you'd assume they're falsely flagged. They don't have a legitimate flag. So it's a very difficult issue. And it's something I think the UN is now, the IMO has just adopted new regulations on registration of ships, whether those are guidelines which have been ignored by the certain number of states, or whether they'll actually be implemented is another issue. But at least they're examining the issue and making suggestions.
Okay, thank you. And I think a question, I mean, we have a few more minutes left. Maybe we'll go for another 5, 6 minutes or 10 minutes. One of the questions that's come up is the judicial remedies available against Iran and US, if any. And I think this is also an important question to really try and understand. I mean, we're all at a loss. What can we do? Right? Iran and the US, they're not parties to the Law of the Sea Convention. The Law of the Sea Convention does have a very robust dispute settlement mechanism. So where does that leave us now as an international community? And I'd open that to anyone, if anyone would like to start.
I just perhaps briefly point out in connection to what Professor Beckman just discussed as well, that yes, falsely flagged merchant vessels is one issue, but then we have a bunch of ships that have been attacked by Iran in the Persian Gulf that are flying a proper neutral flag. In this particular case, of course, while we talked of the importance of distinguishing between jus bellum and jus in bello, one of the judicial remedies basically for those states whose merchant vessels have been potentially systemically attacked is to invoke the inherent right of self-defense under Article 51 of the UN Charter. That would be the most, so to say, escalating judicial remedy, of course.
Mm-hmm. Yep.
So just to jump in on that question, yeah, that's a tricky one. As you pointed out, neither being a party to the Law of the Sea Convention, which has a compulsory dispute settlement part, that is out. Security Council, that's out. I'm pretty sure that China and Russia would probably not agree to Security Council resolution taking some kind of action. However, what is interesting, and going back again to the past, there's the oil platforms case, the ICJ. And this time it was the Iran had brought a case against the US where the US had sent missiles to its oil platforms. And the US had claimed that it was self-defense. Anyway, we won't go into the details. But the jurisdiction there was based on this Treaty of Amity. But I think since the US has withdrawn from that treaty, but what you see is that there are attempts to look at pockets of jurisdiction in these otherwise obscure treaties, maybe like cases that have come under the CERD conventions. But otherwise, it's very difficult, and I think this is the issues. That's why you see unilateral sanctions. But frankly, those haven't worked. These unilateral sanctions against states such as Iran or Russia. Anyway, I welcome to hear from my colleagues as well, thoughts they would have on this.
A quick point on that, I think, which we've talked about with respect to the Dark Fleet, and that's the prospect for advisory opinion, either to ITLOS or to the ICJ, on rights of stateless vessels, the rights of what are the actions that states can take against falsely flagged vessels, etc. What are the minimum a state must do to exercise effective jurisdiction and control if they allow a ship to fly its flag? It's under the Law of the Sea Convention. So some of these issues might be clarified not in a contentious case, but in an advisory opinion.
Okay.
I
Thank
would,
you. Yeah.
if I may, Tara,
Yes, please go ahead.
also point out that it's not only the economic damage that we are speaking of, it's also the environmental damage. So there are already reports of significant oil spills in the Persian Gulf. And, well, the question, of course, arises as to how the law of naval warfare addresses that sort of problems. And you pointed out to the different approaches taken in the Sanremo manual on the law of armed conflict at sea and the more recent Newport manual, which is mostly, though not exclusively, drafted by American scholars. Indeed, the damage caused to the environment is one of the more, so to say, contentious questions that was addressed in the Newport Manual, and in which the American experts quite openly challenged the approach adopted in the Sanremo Manual. However, if I approach the applicable law from a rather neutral perspective, then I would say that there's not really a major dispute between the two approaches, one of the Sanremo manual and the other one being the Newport manual. I think the Americans are simply too concerned with potential limitations that the law of naval warfare might put on their actions in their belligerent operations. But the law of naval warfare really does not put very stringent limitations on that sort of belligerent operations from the environmental perspective. The threshold is very high under the treaty law and under customary international law, as reflected also in state practice when it comes to causing unlawful damage to the marine environment. And in my view, at least, that threshold has not been exceeded. So just to give you one example, under the UK Law of Armed Conflict Manual, it is allowed to target even nuclear submarines. You are not abstained from attacking an enemy nuclear submarine on the grounds that this might pose an environmental disaster. So the approach taken by states is that the long-term severe environmental damage is not of even the sort that we experienced in the Second World War or in the First World War in the French, so to say, battles somewhere in Somme or Verdun or in Normandy. They have an impact on the environment, but unfortunately, this is the harsh reality that the law of naval warfare and as well as operations on the land, they take a toll not only on the economy, but they take a toll also on the environment.
Yes, and I think I would echo that point, and that's some of the one of the questions that have come up. This idea that we have a question and we don't. I think we're running out of time, but just to highlight this, right? This idea that the issues that are happening in the Strait of Hormuz are violating. To what extent are they violating environmental rights or obligations? Also the human rights, right? And is there any and that's also a completely different question. And but it is really having very long-term implications. I'm afraid we've had such wonderful questions and interactions and remarks. I think I will just want to pose one final question to the three panelists to give their final thoughts, right, on where they see this going. If they, I mean, there's a lot of questions about how can we improve the current state, question on, what can the law of naval warfare do to ameliorate some of these issues, right? So just any last final thoughts before we say goodbye?
One final
Bob, first, Bob.
Yeah, go ahead.
One final thought from me relating to your last point, and that is something the IMO has been articulating, and that's the plight of the seafarers that are trapped on
Yeah,
the
yeah,
vessels inside the Persian Gulf, or whose lives are threatened by attacks from either Iran or the United States. So I think it's a very serious human rights issue that should be addressed as a matter of priority.
Yes, I think so. And I mean, particularly to Nilofer and Alexander, I mean, you're editing the book on straits. Your sort of long-term reflections on what you think this is going to be for, sort of states wanting to have strategic control over straits. But anything that you want, actually. That's just my own personal view. But please go ahead.
It's actually a book series, Tara, so
Book
we would
series.
encourage
Oh, oh, yes.
everybody, all our listeners, members of the audience, to contribute to the book series with their
yes.
monographs
Wow.
on different straits. And of course, we are now also working on the Straits Encyclopedia. But well, I think this particular war will not have a lasting, profound impact on the legal regime of Straits. I think the legal regime of Straits as such will remain intact, and this problem will be solved. I'm very optimistic about it personally, but it's my personal view. Um, Otherwise, the only positive thing that I can think of that this particular war has brought about is really the increased interest and relevance of the law of naval warfare. And I think our revision of the Sanremo manual also points out the relevance of this field, and we can incorporate all this state practice into this particular process. Because the law of naval warfare is highly dependent on state practice. So we, as legal experts, we need to, as neutrally as possible, approach that sort of state practice and not say that, well, we should do this or should do that, but instead we need to follow in many ways still the state practice and try to figure out where we are heading at. And unfortunately, in my view, the both ongoing major naval warfares, one in Europe and the other one in the Persian Gulf and the Indian Ocean, point to the fact that we are witnessing an increasing, um, so to say, um, repercussions of economic naval warfare. And this particularly relates to attacks against merchant vessels. It is an unsolved legal problem. How should we treat attacks against merchant vessels? There are some who say that all attacks against merchant vessels, neutral merchant vessels, should be outlawed. There are others who rather take a more, so to say, neutral approach to it, try to follow the state practice. But the way things have developed in the past 5 years is clearly worrying from the perspective of that sort of campaigns against merchant vessels taking an immense toll on the world economy, and this is unfortunately the reality. Thanks.
Thank you very much, Alexander. And the final word to you,
Thank you.
Nilofer.
Well, I will first start off agreeing with Alexander that I think the regime of Straits is pretty solid. And I really can't imagine that there's going to be any changes, particularly on this toll issue and that. So that's good. But when it comes to the laws of naval warfare, and I'm not an expert, Alexander is, but I will say this, and I think that Alexander also encapsulated the gaps. These, number one, something that's so critical based on state practice. And we are in a period where the whole technology of warfare is changing. We know from, again, Ukraine, Black Sea, the drones. Everything is changing, but the law is not, and the consequences are changing. The economic impact to the world is changing because the whole point of blockade is centered on the enemy, but we see it's going beyond that. So I think, and it is very fortunate that San Remo manual is going under revisions, but I really think that these are areas that need to be, in light of what is happening, to seriously review the existing rules on naval warfare. And I will end with this, because we're all international lawyers here. And it may sound odd for me now to reference to the ICJ advisory opinion, but the last paragraph in that opinion, where the court says, basically, of course, climate change is a massive planetary challenge. Well, this is turning into a global challenge. And often international law is faulted, right? It's as if we caused the trouble. We're not, as if international law is the problem. No. International law provides the foundations, the rules. It's really up to states. And in that last paragraph, the court says, we're limited as what the court can do to address these, global problems. We can provide the law, what are the obligations, but not the ones who can actually solve the problems. So I think that's really important, not to blame international law. But what we have to understand at the end of the day is up to states, and there are limits to international law. So I think at some level, I think everyone has a responsibility to ensure that states, may abide by their obligations under international law. If they did, if the US and Israel and Iran were following international law, we wouldn't be in this situation. And I'll end on that.
Thank you, Nilofer. I couldn't have said it better myself. But no, thank you very much. I think this discussion has been extremely useful and valuable, and really also to hear the questions from the participants. Thank you so much for sticking with us. And if I may ask everyone to give a virtual clap to our wonderful panelists who've really shed light on a lot of troublesome and difficult issues. Thank you so much. Yay. And
Yeah.
thank you. We'll see you at the
Thank you, Tara, for your excellent moderation, which so brightly also congratulated.
Oh, this is a real
Thank you so
pleasure.
much, Tara.
Yeah. Thank you. Thank you very much, everyone, and see you next time. We have some administrative things to talk about. So if the panelists don't leave yet. Yeah, okay. Thank you so much. Bye-bye.
Thank you, everyone.
Bye.